Good day, Crime Talk aficionados. We have a great show for you today. First, that former Louisiana mayor, facing up to 17 years in prison following her conviction at that little pool party that she had. The brother of the convicted ex-mayor, he got sentenced to 32 years in prison. I guess it's a family thing. Medical professionals explicitly warned Rob and Michele Reiner not to allow their son to live at home. The former neurosurgeon shot during a police confrontation was fleeing alleged sexual assault charges. Sean P. Diddy Do It Combs' federal prison release date has been moved up. An Amish mother deemed not guilty by reason of insanity. We've got this day in legal history, which who would have thought? Crime Talk made the list. We got the legal quote of the day and our dumb criminal. Let's talk about it.
Lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can check us out anytime on any of your favorite podcasting apps. Before we get started today, let me remind you to go to crimetalksearch.com. Sign up for that background subscription service today. When you do, you'll be able to get a background search done on anyone here in the United States, literally within minutes. It is emailed to you, and you can even get updates when new information becomes available. This information that you're going to get is going to be put in a nice report, and it's going to have everything you need: social media presence, email addresses, phone numbers, home addresses, cars, home liens, judgments, criminal history. Everything you want to know about somebody that's coming into your life, ladies and gentlemen, or maybe you need to decide if I need to let somebody out. We've had more people say, hey, I was going to start dating somebody and they had this in their history, and thank God I didn't let them around my kids. Go to crimetalksearch.com. You're going to be happy that you did. All right, ladies and gentlemen, let's go ahead and open the record Wednesday, March 4th, 2026. And first on the docket, that's right, the former DeRidder, Louisiana mayor, Misty Roberts. Okay, when you have a first name like Misty, I think you're bound to go to prison. And it's probably going to involve a sexual offense. I'm not sure why, but I think it is. Anyway, Misty Roberts, 43, was convicted last night. We brought it to you on our live show of carnal knowledge of a juvenile and indecent behavior with a juvenile after a jury deliberated for less than 1 hour. That's code for, man, she was guilty. Anyway, the charges arose from a 2024 pool party at her residence where some alcohol had been served to some underage attendees, including her teenage son's 16-year-old best friend. Anyway, testimony established that Roberts engaged in sexual activity with the minor, an act observed by her son through a window crack and by her daughter, who described seeing the pair on top of each other. Additional witnesses included the victim himself, corroborating the events, and while Roberts' ex-husband, Duncan Clayton, testified that she admitted to the act and pleaded with him to deny it in text messages. Anyway, prosecutors introduced text messages between Roberts and the victim's mother discussing birth control and emergency contraception, along with the evidence that the DoorDash delivery of some Plan B was made to the home shortly afterwards. Now, Roberts resigned as mayor just days before the arrest back in 2024 and wept upon hearing the verdict, like she really thought she was going to be found not guilty. Anyway, she was released on a $100,000 bond pending sentencing on April 17th, where she could receive up to 17 years. And guess what? She's going to have to register as a sex offender. It's all fun and games until somebody sees you with the 16-year-old, I guess. Anyway, it's even worse when it's your own children and then your husband come testify against you as well. Wow. Can you imagine what Christmas is going to be like around their house? Awkward. Anyway, like I said, the case also involved a prior divorce finalized in 2022 and a contentious custody resolution granting primary residence to the ex-husband in late 2024. Gee, I wonder why. But to make it worse, guess what? Ex-mayor's brother Well, he was convicted of a serious crime of an underage victim as well, and he got 32 years. And you know what they say? A family that does time together stays together. That's right. Brandon Lee Roberts, the brother of former DeRidder Mayor Misty Roberts, was sentenced to 32 years in state prison in early March of 2026 after pleading guilty in November of 2025 to 7 counts of rape. The offense involved repeated sexual assaults against a teenage girl that began when she was just 13 years old and continued for several years, as well as crimes against another young woman over an extended period. Roberts was arrested back in October of 2024 in the same Louisiana community where her sister once held office, with sentencing occurring shortly before her own conviction on unrelated sexual offenses involving a minor. He will serve the full term in state prison without early release. And hey, what can you say? Like I said, something in the family there. Maybe we should blame the parents. Unbelievable, ladies and gentlemen. Something a little overdrive in their sex drive in that particular family. Next, wait till you hear this. Medical professionals explicitly warned Rob and Michele Reiner not to allow their son to reside at their home. That's right. Medical staff issued explicit warnings to Rob and Michele Reiner not to allow their 32-year-old son, Nick, to reside in the family home following a recent change in his schizophrenia medication that could trigger erratic and dangerous behavior. Yet the couple continued with their efforts to help him adjust his prescriptions at their residence there in California. Well, on December 14th, Nick Reiner, back in 2025, Nick Reiner allegedly stabbed both his parents to death at their home. He was arrested hours later and pled not guilty to the 2 counts of first-degree murder on February 23rd of this year. Now, Nick has a documented history of schizophrenia, substance abuse, and prior mental health conservatorship from approximately 5 years earlier. And he also dismissed his treating a psychiatrist roughly 1 month before the whole entire incident blew up. His siblings, Jake and Romy, have withdrawn financial support for his defense, resulting in the appointment of a public defender. And obviously the case carries the possibility of life sentence, even possibility of death, if the small chance that the prosecutor were to pursue that. The mere fact that they were warned, I mean, I'm not saying somebody had it coming. I'm not saying that. But you want to listen to the doctors. I know everybody knows better than the doctors, right? I'm guilty of it too. But there's a reason why they're telling you that. And if they're telling you, don't let the kid in there because his medications aren't right, why would you not do that? And in this particular case, well, it may have got them, obviously it did get them killed. And, we'll give Mr. Reiner the presumption of innocence because we have to. But, wow, enabling, taken to the end will be your demise, ladies and gentlemen. Sometimes you have to be tough. Tough love is the thing you have to do sometimes. I know they tried it. I know the Reiners tried it. They kicked him out. He was homeless for a while, all those things, but he had everything that, most people would only hope for if they were in that same similar situation. And this kid just couldn't get his act together. And also the parents couldn't help him out either. It's tough. They tried, but ultimately it was their demise. That's a neurosurgeon that was shot during a confrontation regarding some sex assault charges. So Thomas Steffens, a 72-year-old retired neurosurgeon, was wounded in a shootout with members of the United States Marshal Service's Fugitive Task Force in the Indian River County there in Florida after police attempted to apprehend him on outstanding sex assault warrants from Colorado. Investigators determined that Steffens had allegedly administered prescription medications to a victim without consent before committing sexual assault. While traveling by bus, because everybody does that these days, towards Florida, Treasure Coast, Steffens reportedly declared he would not be taken into custody alive. And during a traffic stop on the vehicle in which he was a passenger, Steffens refused commands to exit and open fire, striking one United States Marshal in the leg. Task force members returned fire, hitting Steffens multiple times. He was then transported to a hospital and is expected to recover, now facing additional attempted murder charges in Florida alongside the original Colorado offenses. When it rains, it pours, does it not, ladies and gentlemen? No other officers sustained any injuries, thank goodness. Listen, if you have to take a Greyhound bus to Florida to avoid the police, nothing says consciousness of guilt like taking a Greyhound bus, ladies and gentlemen. Seriously, don't ever do it. I mean, it's almost like being named Misty. You're destined for sex assault felony convictions. I just don't know what it is. There's some things that just the laws of the universe dictate it so. Next, Sean Diddy Combs may be moving out a little earlier. That's right. Music producer Sean Diddy Combs, currently incarcerated at FCI Fort Dix in New Jersey, will be released from federal custody on April 25th, 2028, more than a month earlier than his previously calculated date of June 4th of 2028. Now, obviously, Combs was convicted last summer of 2 counts of transportation for the purpose of engaging in prostitution after an extended trial in which he was acquitted of the broader racketeering allegations, and he received a 50-month sentence and a $500,000 fine. Now, the adjustment to the projected release date reflects BOP calculations for good time and other credits during his stay at the FCI. Good for him, Mr. Combs. Everybody wants to get out early. Remember, those last 6 months going to be at the halfway house. You're going to do fine. Good for you. Good for you. I would just keep the freak parties and the baby oil to a minimum, at least while you're on supervised release. Next, an Amish mother deemed not guilty by reason of insanity. So an Ohio court has ruled that Ruth Miller, an Amish mother, was not guilty by reason of insanity in the August 23rd, 2025 drowning of her 4-year-old son and the attempted harm to her 3 teenage children in Atwood Lake. Now, following a bench trial, a trial to just the judge in New Philadelphia, Judge Michael Ernst determined on March 2nd that Miller suffered from a severe mental disease at the time of the offense, rendering her legally insane. Police body camera footage captured Miller in a delusional state, expressing beliefs that she and her family would be swallowed by a fish at God's command. 3 independent mental health professionals who examined her concurred that she experienced an acute psychotic crisis involving grandiose delusions. Miller remains in the county jail for a brief period pending a March 13th hearing to decide her placement and treatment. The case concluded without witnesses' testimony or closing arguments, relying instead on expert reports and video evidence. Sometimes people, ladies and gentlemen, are just, they're not sane. Now, she's not going to get a free pass. She's going to the state mental health hospital, but she's not going home. So remember that, okay? And in this particular case, quite obvious that she, was legally insane. Next, this day in legal history. On March 4th, 1789, the first Congress of the United States convened at the Federal Hall in New York, marking the date when the newly ratified Constitution replaced the Articles of Confederation and the federal government formally began operations. Now, obviously, the foundational constitutional event established the bicameral legislature, set the stage for the creation of the executive and judicial branches through subsequent legislation, such as the Judiciary Act of 1789, and it solidified the framework of the separated powers and federalism that continue to define American governance. On this date, in 1998, the United States Supreme Court ruled in Uncal v. Sundowner Offshore Services, Inc., that Title VII of the Civil Rights Act of 1964 prohibits sexual harassment in the workplace, regardless of whether the harasser and the victim are the same sex. The case arose from severe harassments experienced by Joseph Ancale, an oil rig worker, and clarified that discrimination because of sex under federal law does not require opposite sex parties. This ruling significantly expanded workplace protections and established a precedent for same-sex harassment claims that remain central to employment law jurisprudence. And next, are this day in legal history, March 4th, 2024. Who knew Crime Talk made the cut for this day in legal history? That's right. The United States Supreme Court issued a unanimous per curiam opinion in Trump v. Anderson, holding that the individual states lack authority to disqualify candidates for federal office, including the presidency, under Section 3 of the 14th Amendment. The ruling reversed a Colorado Supreme Court decision that had removed former President Donald Trump from the state's primary ballot and affirmed that the enforcement of such disqualifications rests exclusively with Congress. The decision provided critical clarification regarding the state versus federal powers in presidential elections and carried immediate implications for ballot access nationwide. Now, like I said, some people are going to say, oh, really, Scott? What did you do in that particular case? Well, the case was originated here. And I was asked by the president's local counsel here, an attorney, obviously, and a former Secretary of State, is if we would assist in the case with a amicus brief that was filed before the Colorado Supreme Court. And it was by two very distinguished authors that literally had spent their life arguing this particular issue. Because, you know, in academia, that's what people do. Obviously, the Colorado Supreme Court ignored the sage advice that was given by the amicus brief that we co-sponsored by Professor Seth Barrett Tillman, an American national and a member of the regular full-time faculty at the Maynooth University School of Criminology in Ireland. And Professor Tillman had co-authored publications concluding that Section 3 is not self-executing, right? Total interesting stuff, right? Anyway, the case, Supreme Court here in Colorado said the Secretary of State, who's now running to be the Attorney General, probably one of the biggest idiots ever to graduate from law school. I'm not saying that because, well, she opens her mouth. She's an idiot. Anyway, case goes to the United States Supreme Court. Look, there it is. Oh, this side here. Got to go to the United States Supreme Court. Got to see the argument. Was literally second row back, right behind counsel table. It was exciting. I'm not going to lie. Probably the highlight of my 31-year career. And like I said, some of the compelling legal issues. Plaintiff's request relief is barred by the Griffin's case from 1869. Griffin's case is persuasive authority that settled the meaning of Section 3. The Colorado Supreme Court engaged in improper speculation about the Chief Justice Chase motive. In 1788, 1868, and today, officer of the United States in the Constitution extends exclusively to appointed positions and not to elected positions. This is some riveting, total dork stuff, ladies and gentlemen, as it relates to the Constitution. But after all, that's right, the Constitution matters. And he says the president is covered by the religious test clause, and it goes on and on and on. This is the official amicus brief that gets filed. See, they bound it all nice. And as you can look and see here, Scott Reich Law Firm, made legal history. United States Supreme Court. Did I argue it? No. I reviewed it. My name was on it. Supreme Court lawyer. Anyway, we digress. How about a legal quote from Trump v. Anderson? Decided March 4th, 2024, where the United States Supreme Court concluded Scott Reich was completely correct, which is why you should always listen to me. We conclude that the states may disqualify persons holding or attempting to hold state office, but the states have no power under the Constitution to enforce Section 3 with respect to federal offices, especially the presidency. That's right. We were right. That's right. Don't doubt me, ladies and gentlemen. If the United States Supreme Court can agree with me, you got to know that we're doing something right here. And then finally, our dumb criminal of the day. A political candidate in North Carolina was arrested and is facing charges related to a hit and run charge. I know. So according to the arrest affidavit, Chad Minson Stewart unlawfully and willfully did fail to immediately stop after he collided in a school bus on February 26th. The records show that a warrant issued on the 27th of February, he turned himself in and was charged with failure to stop for a school bus. A hit and run, failure to stop and exchange information as well. Anyway, Mr. Stewart was released from the Johnson County Jail not long after he turned himself in and posted a $20,000 bond. You would think he had killed somebody. Anyway, he was scheduled to appear in court on April 10th. And he is one of three Republicans running in Tuesday's primary election for the Johnson County Board of Commissioners in the District 3 seat. Certainly, that doesn't help your odds when you're an alleged criminal. Well, sir, you are a dumb criminal of the day. You should have just stopped. Don't hit school buses. They kind of make them big, bright, and yellow, and they put those little stop things out so people can see it. Don't be stupid. Don't hit a school bus. All right, ladies and gentlemen, that's all we have for today. That's right. March 3rd, March 4th, the date that Crime Talk made history. Anyway, thanks for watching. We'll see you next time. Remember, the Constitution matters.